Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We're talking about contracts today. What we looked at before the break is just the different types of contracts that are recognized within our legal system. And we started looking at the general clauses one can expect to see within a contract and what those mean. With me in studio, I have Aslam Moosajee of Norton Rose. Aslam is a director of Norton Rose, and we're very privileged to have him with us today. Aslam, just before we went to the break, we started talking about conditions precedent or suspensive conditions, and you were going to take us through exactly what that means. And also, you mentioned that people don't read contracts carefully enough and maybe don't understand what certain terms and clauses mean, which can impact how that contract then pans out.
Let's start with a condition precedent, or sometimes called a suspensive condition. A suspensive condition is a condition that is inserted into the contract, and until and unless that particular condition is fulfilled, the contract is not binding on the parties. Again, I think it's easy to deal with it with reference to a particular example. Let's assume I need to buy a bigger house, but I can't afford the bigger house unless I can sell my existing house. Under those particular circumstances, what I ought to be doing is entering into a written agreement, which includes a suspensive condition, which says that this agreement is subject to the fulfillment of the suspensive condition, that by the end of November this year, I would have sold my existing house for at least R1 million. Now, if by the end of November I've sold my existing house for R1 million, the current agreement then becomes binding and I can go ahead with the sale of the new house. If, however, I run into difficulty and I can't get a buyer for my existing house at R1 million, then the current agreement never comes into existence. I should also say that people have from time to time tried to manipulate these suspensive conditions that are contained in the agreement, and what they try to do is they rush into an agreement without properly thinking about it. They say, there's the suspensive condition there, and if I have a change of heart, I can just make sure that the suspensive condition does not get fulfilled, and therefore the agreement is not binding on me. Now, I've got news for those people as well. It's not that simple in our law. If there is the suspensive condition I gave you in my example, but I don't take steps to actively market my house, perhaps by getting an agent or by me advertising the sale of the house and actually trying to find a buyer, then the seller of the second house can turn around and adopt the position that you have frustrated the fulfillment of that particular condition. And because you frustrated the fulfillment of that particular condition, the seller will argue to a court that that condition must be deemed to be fulfilled. And if a court's prepared to deem the fulfillment of that condition, then despite that condition not having been met, the agreement is binding on the parties. Also, what is relevant to the question of suspensive conditions is those suspensive conditions are more often than not inserted for the benefit of both parties, but just for the benefit of one party. So in the example I gave you, the suspensive condition was inserted for my benefit. And if it's inserted for my benefit, I have the right to waive the condition. But I have to do that prior to the expiry date. So on my facts I gave you, the due date for the fulfillment of the condition is the 30th of November. I could go back on the 28th of November and say, listen, I've managed to secure funding from an alternative source. I now no longer need to sell my existing house, and I waive fulfillment of the condition which required me to sell my existing house. And under those circumstances, both parties will still be bound by the contract. If, however, I wait till the 1st of December, by then it's too late, because the due date has come and gone, the agreement has lapsed for the failure to comply or to fulfill the condition precedent. And under those circumstances, unless I can get the seller of the house to agree again to sell the house to me, there wouldn't be a binding agreement between the parties.
All right. Aslam, a lot of the time, these contracts seem to go ahead irrespective of maybe there are often many suspensive conditions, and maybe one of them hasn't been fulfilled, but somehow, it's overlooked, and everything else then pans out in terms of the contract. It then eventually ends up being, there's a breach and there's a legal battle. What is then the position or the state of that contract?
If the conditions have not been fulfilled, the difficulty is there isn't a binding agreement. And unless you can try to rely upon certain representations made to you by the other party, and you can show that you've acted to your detriment by virtue of those representations, and then you rely upon what we lawyers commonly refer to as estoppel, it becomes very difficult to ensure that you get a court to enforce the agreement where the suspensive condition had not been fulfilled. And often people will tell you, but that's just unfair. It wasn't my fault. Unfortunately, the law is not always about fairness. And the law is where if the conditions are not fulfilled, you don't have a binding agreement. And it's only in certain isolated, instances that people get around the fact that there isn't the fulfillment of the condition precedent. More often than not, I find in practice that if the conditions precedent have not been fulfilled, the court's not going to recognize that agreement is binding.
Sure. Moving on, I think a lot of people come across contracts that have already been drafted, either by an attorney or in favor of one of the parties, and they are presented with an agreement to sign. They can look through it. What their power to adjust that is, differs in the circumstances. But what is the danger that a person faces where someone else has drafted an agreement?
What I find is often when you're negotiating and you're doing a deal, there's lots of excitement and the discussions and everybody's friendly and, this is all just fantastic. And then what happens, the document gets presented to you, and in the excitement, you want to conclude the deal quickly and you don't want people to change their mind. And then you rush into signing the agreement without properly reading the terms of the agreement. If another party has presented an agreement to you, you should at the very least take a few hours to properly study the terms of that agreement, to make sure that it correctly reflects the intention of the parties. And often, we're all not used to the legalese. If you're entering into a complex transaction or a transaction of significant value, sometimes you're better off going to an expert that specializes in the drafting of contracts and get him to read the agreement with you, to explain the terms of the agreement, and also to explain to him what was important to you that was raised and agreed in the discussions. Because those sort of things, then the attorney can look at the agreement. If he's skilled enough, he's going to be able to tell you, but what you've just told me is not recorded in the agreement. That's not recorded as the intention of the parties. So it's important that you get somebody, if you don't have the necessary skill and experience, to look over the contract with you and to ensure that the contract reflects what was agreed between the parties. It's often too late to try to do damage control once you've already concluded the agreement, and then you say, no, but I didn't read the agreement. Courts don't take too kindly to that sort of approach, and it's often a lot more difficult to get those sort of agreements rectified, to say it doesn't correctly reflect the intention of the parties. Yes, if there's a mistake common to the parties and both parties are honest and they agree that, the courts will allow the rectification of the agreement. But I'm talking of where we live in a world where people often take chances, people are not often honest. You need to be sure that you're reading the contract and it correctly reflects the intention of the parties. The other thing is you need to understand what certain standard terms in a contract mean. And two typical examples that we as lawyers often grapple with in practice is a whole agreement clause or a non-variation clause.
Aslam, I'm going to stop you there. Let's take the break and we'll deal with those clauses when we come back. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bana. Now, part of going through our everyday lives and just conducting ourselves generally, both in our personal capacities and in terms of business, involves entering into contracts. we all enter into various types of contracts on an ongoing basis, and these can be sale and purchase agreements, service supplier type contracts, employment contracts, lease contracts, even informal IOU type contracts. We know as legal people that seeing a written legal document can be quite confusing and daunting for the average person. It's filled with legal terminologies and clauses that you might not understand how to deal with or what they mean. So what we are exploring today is just the different types of contracts that are legally recognized within our judicial system, as well as the common clauses and principles that you can see in contracts and what they mean. With me in studio to help interpret and break contracts down into a simple, understandable body of knowledge is Aslam Moosajee. Aslam is a director at Norton Rose Attorneys. He has over 15 years of experience, and he predominantly deals with commercial litigation. Aslam, assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to the show.
Wa alaikum salam.
Aslam, let's start off by looking in its most basic form. What is a contract?
A contract, Yumna, is generally an agreement that is concluded between two or more people. And what would often happen is one person would make an offer to do something or to deliver something, and the other party or parties would accept that offer, and as part of accepting the offer, generally the offer would stipulate a price at which the delivery of the service of the good is going to take place. There's then the acceptance of the offer, and that often gives rise to a contract in our law. And in our law, a contract can be concluded orally or in writing, or you can have a situation where you have a partially written agreement and a partially oral agreement.
All right, so in a nutshell, what you're saying, and just to make it clearer for our viewers, is that a contract doesn't necessarily have to be in writing. It can be oral.
By and large, that's absolutely correct. And I deliberately say by and large because there are certain exceptions. In our law, certain types of agreements have to be in writing in order for them to be enforceable. A typical example of such an agreement is an agreement in respect of the sale of land. Other examples that quickly come to mind are certain long leases, or if you're concluding a suretyship agreement, those agreements have to be in writing in order to be enforceable. But apart from that limited category, our law does recognize oral agreements. The difficulty often with oral agreements is how one goes about proving the terms of the agreement. And it even becomes more difficult if you only have two parties that were present at the time the discussions occurred. You then have no witnesses that can verify which party is telling the truth and which party is not telling the truth. Now, the way our courts often deal with those scenarios is people get subjected to cross-examination in a witness box. But even after a cross-examination process, sometimes a court cannot determine who is telling the truth and who's not telling the truth. And under those circumstances, our courts then fall back on what they call the onus rule. So the party generally that is alleging that this contract was concluded, these were the terms, and there was the breach. If that particular party is unable to prove all of that, the court says, well, I can't tell which witness is lying, but since the particular party that's making the allegations has not been able to prove that on a balance of probabilities, I have to find against that person and dismiss the claim. So all I'm saying is that while the law recognizes oral agreements, if you're entering into a complex transaction of significant value, it's in your interest to ensure that the contracts are reduced to writing and signed on behalf of the parties so that there's less of a debate later about exactly what the parties agreed.
All right. There's also a third type of contract, and that is what we call a tacit agreement or a tacit contract. What does that mean?
A tacit contract is where the express discussions of the parties don't necessarily give rise to the agreement, but the unequivocal conduct on the part of the parties point to the conclusion of a contract. And I think it's easier to explain this with a real-life example. Assume you have two people that co-own a farm. They live on the farm together. They share expenses in relation to the farming activities. They share the income of the proceeds of the farming activities. Now, under those circumstances, even if the parties did not actually sit down and agree that they're going to be partners in the farming business and they're going to share the expenses equally and they're going to share the income equally, a court will recognize a tacit partnership agreement having come into existence by virtue of the conduct of the parties. You also then have a scenario where even if there's an express agreement, there may be a tacit term that a court recognizes in relation to that express agreement. Again, if I got to give you a real-life example, assume that I phone a tax advisor. I say to the tax advisor, I need your assistance and your services. I need to make an appointment with you. You need to help me to complete my SARS tax return. I make an appointment, I go and see him, he spends time with me, he advises me how to complete the tax return gets completed, gets submitted to SARS. If after that he sends me an invoice, I can't then turn around and say, but I didn't expect you to charge me and I didn't agree with you that you could charge me. I think under those circumstances, the court is likely to say that the parties, by their conduct, had tacitly agreed that the services would be rendered and those services have to be paid for at a reasonable rate. So as long as the invoice then is based at reasonable rates, the court will assume that that was a tacit term of the express agreement for the rendering of services between the parties.
All right. It seems to me that the proof in these instances is really circumstantial. You're going to look at the conduct of the parties and what was happening in reality as opposed to the writing that's been recorded.
Absolutely. I mean, in the scenario I just gave you, the tax advisor may have not written back to you and said to you, yes, I will assist you, but these are my charges and so forth. But I think people can generally expect to have to pay for services. It's no different, for example, to going to a doctor. When you go to the doctor, more often than not, the doctor is not going to tell you up front, listen, I'm going to charge you for the consultation and this is what I'm going to charge you. But you expect to be charged, and as long as the charges are reasonable, you're obliged to then pay those charges.
Aslam, let's move on to looking at some of the terms and the principles that we come across in contracts. What are, just generally, your starting point? What are you going to see in a contract?
If you've got a contract in writing, you'll often find a contract will have a definitions clause, for example, defining certain terms that will crop up in that agreement more than once. You'll then have an introductory paragraph dealing with what the nature of the contract is and why the parties are concluding the particular agreement. Then you'll have the essential terms of the particular contract. So if it's a sale agreement, you'll have details of what is being sold, when delivery is going to take place, where delivery is going to take place. You'll include in the agreement details of the purchase price, when payment of the purchase price becomes due, how payment is going to be effected. Some people expect payment by EFT, others would expect a check to be delivered at a particular address. And then you'll also have certain general clauses in a particular contract. And what I find in practice is often people don't read and fully understand the implications of those general clauses. And then also occasionally you may find a suspensive condition or a condition precedent, and those words are often used interchangeably in a particular contract.
Aslam, I'm going to stop you there. Let's look specifically at conditions precedent when we come back after the break, just because I think we can elaborate a little bit more on that. Let's take our break now, and we'll come back to that. Stay tuned for more on contracts and the different types of clauses that we see generally in contracts. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, where we are talking about contracts, and in specific we are dealing with different types of clauses that you see in contracts and what they mean. I have with me in studios Aslam Moosajee from Norton Rose Attorneys. Aslam, just before we went to the break, we started dealing with certain clauses that you wanted to explain. Let's deal with that before we move on.
A whole agreement clause is often a clause which says this agreement constitutes the whole agreement between the parties, or the sole record of the agreement between the parties in relation to the subject matter. What that effectively means is all that has been agreed has been recorded in the document. So if I go back to my example, I agreed to purchase your motor vehicle for 100,000 Rand. I agree I got to pay you by the end of October, and on the 1st of November, you're going to deliver the motor vehicle to me. We also agree that before I take delivery of the vehicle, you're going to change the tires because it's too old. If the agreement doesn't mention anything about the tires and has the whole agreement clause, and come the 1st of November, you deliver the vehicle to me with old tires, it becomes very difficult for me to then say you've breached the agreement, because the written agreement that I'm relying upon doesn't stipulate an obligation on your part to change the tires, and in fact there's another clause that says that's the whole agreement between the parties. Another typical standard clause you find is a non-variation clause, which essentially says no amendment or variation or addition to the terms contained in this document shall be binding unless reduced to writing and signed by both parties. So what happens is sometimes after an initial agreement is concluded, parties then want to change certain things. They sign the written agreement, it contains the non-variation clause, they then agree things verbally, but they don't reduce that to writing. That verbal agreement, it becomes very difficult to rely upon, because you had initially agreed that there would be no binding amendment to the agreement unless reduced to writing and signed by the parties. So understand what's in your contract and make sure people are complying with the terms of the contract.
Now, we've mentioned several times throughout the show the concept of breach.
Yes.
What do we mean when we are talking about breach of a contract?
In simple terms, breach is when somebody is not performing his or her obligation in terms of the agreement. Often somebody hasn't paid on time or hasn't delivered on time. That would result in a breach of the agreement.
All right. Now, usually the contract would stipulate, in the case of breach, these are your remedies, and one of those remedies, for example, could be damages. What are the general remedies that are available, and what does damages mean?
If there's a breach of the agreement, you'd often, unless there's something contrary in an agreement, give notice to the other party to remedy that breach within a reasonable period of time or within a stipulated time period in terms of the contract. If that party fails to remedy the breach, and it's a material breach, so an important breach of the agreement, for example, the failure to pay the purchase price would be a material breach of the agreement, then you're entitled to cancel the agreement and in addition claim damages. Or what you can do is you can elect to say, I'm not cancelling the agreement, I choose to enforce the agreement, and you claim what us lawyers refer to as specific performance of the agreement. That would effectively be you claiming payment of the purchase price, or you claiming delivery of the vehicle. I mentioned damages earlier. When it comes to damages, you have to allege and prove before a court that there was a contract that was concluded, there's a breach of that particular contract, and you've suffered damages as a result of that particular breach. Now, in theory, that all sounds very, very simple. But it's not that simple, because our law also looks at this concept of whether the damages are too remote and asks questions about whether or not those damages flow naturally and generally from the breach, or whether those are damages that were within the contemplation of the parties when the contract was concluded. Now, again, all of that sounds fairly complicated. Let me try to break that down in a simple example. Let's assume I'm a farmer, I got a tractor. My tractor breaks down, I go to somebody and ask him to repair the tractor. He agrees that he'll repair the tractor at 1,000 Rand, and I can collect the tractor on the Monday. I go there on the Monday, he's failed to repair the tractor, he's refusing to do so, and he says, there's your tractor, take it and leave. He's clearly breached his obligations in terms of the agreement. I then have to go to a second repairer. I'm now more desperate. He quotes me 2,000 Rand to repair the tractor. I agree that he can go ahead. He repairs it. It's now cost me 1,000 Rand more than it was originally going to cost me. That's easy. It's easy for me to show that those damages flow naturally or generally from the first repairer's breach. The more complicated question is whether or not, by virtue of the fact that I didn't have the tractor, I couldn't plow the fields and I couldn't earn an income, whether I can claim those damages. Now, those damages can only be claimed if you can show that the first repairer knew that I only had one tractor, that I used the tractor on my farm, and that I needed the tractor to plow the fields, and I was going to suffer a loss of income if I didn't have the tractor by the Monday. If I can show that he was aware of all of that, then it's easy for me to also claim the loss of income. But if I can't show that he was aware of that, the court's going to take the view that those are damages that are too remote, and the first repairer is not liable to pay those damages. The other issue that complicates the question of damages is the concept of a mitigation of damages. So even if a party is guilty in breaching the agreement, but that party can prove that the innocent party did not take reasonable steps to reduce the loss, then the damages ought to be reduced. And again, if I go back to an example where if I lease a property to you and we agree that the lease term is 1 year, after 2 months you breach the agreement, you leave and you refuse to pay me the rental for the next 10 months. If you can prove that I would have been able to let that property by taking reasonable steps within a month, then a court's not going to give me damages for 10 months, but will restrict my damages to only 1 month because I failed to mitigate my damages.
Sure. Aslam, what are some of the other clauses that could be dangerous or tricky and people should be particularly aware of when reading contracts? And one that comes to mind is the domicilium clause, where you elect an address, where you're going to, for example, accept notices and legal notices. Those are clauses that people should be aware of, have significant importance.
Absolutely. A domicilium clause is really a choice of address clause at which you will accept any notice, including a legal notice in terms of the agreement. And the obligation, if I'm going to sue you, I generally need to give you notice. And a court will not entertain that dispute unless I've given you notice. But I can give you the notice by delivering it to the chosen address. So you need to make sure that if you're choosing addresses and if your addresses change, that you change your chosen domicilium address. And if you don't change those chosen domicilium addresses, you should at the very least make sure that at the previous address, the people are aware of your contact details and they forward to you any notices that you receive. But that's not first prize. First prize for me would be that you give notice to say, I've chosen this address, I've now moved, this is my new address, please make sure that all notices are sent to this particular address.
And just to make it more clear to the viewers, the risk that you take where you've got a domicilium address that you've moved on from, or that you're not always present at and the people are not sure how to pass documents on to you, is that a legal notice could be served on you and it doesn't come to your attention and a default judgment can be issued against you.
Absolutely. And you can apply to court for a rescission of the default judgment. But then you got to do the running. You got to show that you were not in willful default and you did not simply ignore the legal notice. But then more fundamentally, you got to prove what your defense is. And you start carrying and attracting onuses in order to get the judgment rescinded. Whereas if you were sued and you defended the proceedings, the other party carries the onus of having to satisfy the court that his or her version is the correct version.
Aslam, it's been a pleasure having you in studios to discuss contracts with us. I think the subject can probably do with more airing out, and we hope to see you in our studios again in the future.
Inshallah.
Thank you so much. Well, you heard a little bit about contracts, and hopefully it's simplified contracts for you, and you will read contracts with a little bit more understanding and also more care, keeping in mind some of the advice that you've received today. Don't forget to email me on legalease@itvnetworks.tv and follow me on Twitter @Yumnabana. We look forward to seeing you again next week. Assalamu alaikum wa rahmatullahi wa barakatuh.